A very good evening to respected Mr. President, respected jury, and the highly respected of the highly mistaken opponents. I would like to really break down the topic of the debate. Is human dignity a fundamental right under our constitution, or is best a constitutional value? Now, to break down this debate topic, we have to understand what is the difference between fundamental right and a constitutional value. A fundamental right is very well defined. A fundamental right is very well backed by precedents. A fundamental right is very well backed by the statement of law. And a fundamental right is something that we can all agree upon cannot be breached. Now, why do we contend as Manoneet Dwivedi from UPS Dehradun that is speaking against the motion that human dignity is at best a constitutional value? Because I strongly believe that human dignity needs to be breached and human dignity needs to be curtailed in very specific and very important matters. We understand by our own understanding of law, since we are students of law right from a first year law student to a sitting judge, that human dignity is not that well defined. Human dignity does not have its basis in judicial precedents. Human dignity does not have its basis in settled law, in statutes, and human dignity is still ever evolving, ever changing, and human dignity is still not extremely well understood by us, the students of law. Now, what the difference between fundamental right and a constitutional value is what defines human dignity to be said constitutional value. This human dignity, being a constitutional value, is something that is highly regarded by judges, that is highly regarded by advocates, and that is highly regarded in the specific judgments that have been mentioned. A lot of judgments were thrown around: the Menka Gandhi case, the Khadak Singh case, the Francis Corelli case. But you have to understand that the judiciary, in all of its wisdom, did not consider it to be a fundamental right, as they do consider other things to be a fundamental right when it came to human dignity as a principle. You have to understand that the topic of the debate is not whether topics stemming from human dignity are matters of fundamental right or a constitutional value. You have to understand that the topic is not whether human dignity in other countries, in other jurisdictions, in history, in other geographical tenets is considered a fundamental right, but whether under our constitution it is a fundamental right or whether it is a constitutional value. Under our constitution in India, where human dignity has several different facets, has several different topics under which we have to analyze the human dignity, and wherein matters that are so different from matters concerning the rest of the world are considered a matter of human dignity. A lot of countries in the world do not consider matters of patrilineal lineage or matrilineal lineage a matter of human dignity. Yet in India it remains, and it is explicitly said that you cannot talk about someone's patrilineal and matrilineal lineage and let it be as something that is trivial, as something that is inconsequential. Human dignity under our constitution, under our jurisdiction, in our country is very, very different from what examples we have been hearing of different countries, of different jurisdictions, of different thought processes that do not apply to our country at all. You have to understand that that a fundamental right, when guaranteed in our country, is very specific, is very clear in its wording, and is very clear in its intent. That why it has been recognized as a fundamental right. It is not a matter of joke, and it is not a matter that should be taken lightly. We understand that a fundamental right, when granted in our country, is something that is protected by the highest of the courts, the Supreme Court, and every single High Court and every single court that comes below it. You have to understand that something as vague, as subjective, and as unapplicable to the principles and to the very basics of fundamental right, such as human dignity, cannot be talked about as anything that can be enforced as a fundamental right. Now, this brings me to the last part of my argument. If human dignity is so inconsequential as a fundamental right, if human dignity cannot be guaranteed as a fundamental right, what does it stand as? It stands, that's right, as a constitutional value. Now, why does it stand as a constitutional value? We understand that in so many judgments, in so many ways, the Supreme Court and different high courts have told us that human dignity is something that they value very, very highly. We have to understand that the value of human dignity is so persuasive that that judges and advocates alike refer to human dignity in their arguments when it comes to very basic legal arguments also. We have to understand that human dignity as an enshrined constitutional value and human dignity as something that has to be taken care of while delivering any judgment, while making any argument is extremely important. And thus human dignity does stand as a very important constitutional value. A constitutional value is something that genuinely makes the bedrock of any argument, or any kind of legal thinking that we support. We more often than not claim justice, equity, and good conscience, and these are principles that we are moved by. These are not settled principles that we talk about as something that can be enforced, but as something that has to be kept in mind while we are talking about anything in the legal sense. Thus, human dignity as a constitutional value stands above and beyond, and is much more justified, and is much more susceptible than human dignity as a fundamental right. And thus, I am proud to be against the debate topic: is human dignity a fundamental right under our constitution, or is it best a constitutional value? Any questions?
Again, come, ask question.
Sir, was debating on the point that human dignity is a constitutional value. Do you think and do you believe that if something violates a constitutional value, let's say a legal statute, if it violates a constitutional value, would it be unconstitutional or not?
Sir, did you pay attention to when I said
I
that?
did, sir. Sir, just please answer my question.
Did you pay? I'm answering your question.
Sir, please do not cross question, sir.
Did you pay attention? You cross question.
I did, of course.
Yeah.
I did, of course.
Did you pay attention to the fact when I said that it is vague and it is subjective?
Sir, my question is very simple. If something is a constitutional value and if a statute violates that value, does it become unconstitutional or not?
Is it subjective or not?
Sir, you're not getting my point. Let's say
I will get to the exact words of your question, but did you get it when I said that it's vague and subjective? That human dignity, when defined, is vague and subjective.
I absolutely did, sir.
When I approach a court and I say that this specific constitutional value has violated a statute, and this specific constitutional value has been violated, then it is up to the court, and it is up to the wisdom of the judges to decide whether human dignity specifically in that case has been violated or not, whether that constitutional value has been violated or not, whether that fundamental right that we talk about is not violated, is something that we can understand by precedents, is something that we can understand by very well laid principles of law. But we cannot apply the same thinking to a constitutional value. That we have to let up to the wisdom of the judge.
Exactly my point, sir. If we go by your logic, then whenever the human dignity of any individual or a community has been violated, that statute has been said to be unconstitutional, or the courts have made that statute unconstitutional. So if we go by your own logic, doesn't human dignity become constitutional right in itself?
But then yet again, it is not settled as a fundamental right. It is not settled as a constitutional right. Human dignity could have been settled, but it has not been settled because it is so vague and subjective. The basis of my arguments was that it is so vague and subjective that it cannot be settled as a matter of fact.
Thank you.
He has to speak against the motion. What can he do?
I absolutely get that.
Any more questions?
Any questions?
Thank you.
Thank you.